Good afternoon, everyone, and welcome to Butzel Long's webinar, The CARES Act, What Small and Mid-Sized Businesses Need to Know. During this afternoon's presentation, please feel free to submit questions to the presenters using the GoToWebinar question panel. Our presenters will answer as many questions as they can at the end of the webinar, time permitting. Also, a copy of this presentation will be made available this afternoon on the webinar event page and Butzel Long's Coronavirus Resource Center on butzel.com. So with that housekeeping out of the way, I would like to introduce Butzel Long shareholders Bernie Foos and Brett Miller, and associates Jonathan Kirkland and Stephen Etherly. Bernie?
Thanks, Jonathan, and good afternoon to everyone on the webinar. Hope everybody is enjoying their own personal quarantine. Again, my name is Bernie Foos. I am a shareholder here at Butzel Long. In normal times, I specialize in emergency business litigation. Brett Miller, my colleague, in normal times, and even right now, specializes in labor and employment. Jonathan Kirkland is one of our real estate and corporate gurus, and Stephen Etherly is also a business litigator. All of us, along with a few others at the firm, have been inundated with information and have really gotten up to speed on this CARES Act, and whether we liked it or not, have become somewhat experts in what's happening with this piece of legislation and now law. So a few preliminary things. Much like many of you, I am working from home per Governor Whitmer's order. I have 4 coworkers under the age of 10. So if you hear some screaming, some crying, I would just appreciate if you guys be patient and don't judge me. And in return, I will not judge you for likely being in your pajamas for the 4th day straight. So with that, let's get on to it. We are going to talk about a number of things today. I want to give you a quick breakdown of the CARES Act itself. It started a few weeks ago when all this hoopla started happening. Marco Rubio introduced some legislation. It was 400 pages, and we read through that. And then the House came and got involved, and that was an additional 1,400 pages. We read through that, and ultimately they came through and knocked it down to 800 pages, double spaced, but 400 pages if you want to go single space. So a lot there and a lot to go over, obviously. The biggest part of the CARES Act and the primary component we're going to discuss today for the small and mid-sized businesses is the Paycheck Protection Program. That's probably what most of you have heard about on the news or in the newspapers. I put in the word free money. That's the question I get. Is it true, Bernie? Is it true that the government's going to give us free money? My response is, well, nothing's free, but this, compared to most programs, is if you qualify, is pretty darn close if you use it the right way. So we're going to go through the ins and outs of that. Brett Miller and I are going to go through some common questions we're getting from our clients and employers about the CARES Act. Certainly some of them have already decided to do some kind of RIF, layoff, furlough, or pay cut, or some are seriously contemplating doing that, as I'm sure many of you on this webinar are thinking about. The CARES Act certainly alters that potential business decision, and we'll go over some of those questions and the interplay. For those of you who may be close to the eligibility mark but just miss out, perhaps you're over the 500 threshold or another applicable threshold, there still might be some available opportunities for you, albeit not the quote free money end quote, but still pretty good deals that you might want to take advantage of. Steve Etherly will talk about that. And then back to the small businesses and mid-sized businesses. In addition to the CARES Act, or even within the CARES Act, there are some other programs that you might qualify for and might want to consider. And then, of course, we'll end with some questions, time permitting. So let's talk about just a quick breakdown of the act itself. I mean, these are big numbers. I mean, I'm old enough to remember when there was a lot of debate about the wall and how much money that was going to be, you know, 2 billion versus 10 billion. And that just looks like peanuts, along with all the other things that they were talking about, you know, over the last couple of years. I mean, this is big numbers, okay? $2 trillion. in this package. It is the largest stimulus or rescue package in American history. It is certainly unprecedented both in its size and really with the speed with which it was enacted. Looking through this law, you got the intent of why they're doing this, but lawyers like myself and the rest of us, you start looking at the text, and the text doesn't actually match up to the intent. And that's what happens when you rush something like this out. So we're going to try to give you as much clarity as we can, but I can tell you right off the outset here, this is phase 3. There may be guidelines, regulations that alter some of these things we're talking about, and they're already talking about phase 4 and phase 5. So who knows where Congress may take us on that. But of the $2 trillion, $600 billion for individuals. You've seen that with the individuals and the couples and the kids and the direct checks that that are supposed to be coming out. There's $500 billion for the larger corporations. Again, Steve Etherly will touch on that. $377 billion for the small businesses, and also included mid-sized businesses. The $349 billion of that is this Paycheck Protection Program, and also $340 billion for state and local governments, and $180 billion for public services. So a lot of money. Again, we're talking about small and mid-sized businesses, and the CARES Act, if you look at it and try to make it simple, it really modified the Small Business Administration Code and the acts that are related to that. Okay, so we're certainly talking about the mom and pop shops, the restaurants on the street here, but also a lot of automotive suppliers and manufacturers, parts manufacturers, and even professional services firms. All these kind of businesses, while different, certainly can fit into how this act defines, quote, a small business, end quote. So let's get into the Paycheck Protection Program. Again, this is really the hottest topic out there. This is the one you're hearing Secretary Mnuchin and other members of Congress getting on TV and talking about, right? They're saying, hey, rehire your employees and we'll pay for it. I mean, literally just yesterday, that's what they're saying. We've enacted the legislation. The purpose of this program, whether you're a restaurant down the street or you're a smaller automotive supplier, if you've let people go, rehire them, we'll pay for it. That's the crux of this. And if you do that, and Mnuchin again said this yesterday, if you do that and you pay the people, we'll forgive that loan. That's what they're saying, okay? And for the most part, that is actually true in the act itself. So we're going to walk through who is eligible, okay? What can the loan be used for? Can it actually be forgiven? They're saying it. Is that actually true? What is the process? Let's say you want to apply for the loan. How does the process actually work? We'll go through that. We'll talk about those RIFs, those furloughs, and the interplay with the act. And again, we'll talk about other programs that might be applicable and available. So who is eligible? There's really 2 prongs. One, businesses, startups, veteran organizations, and nonprofits with 500 employees or fewer are going to be eligible. A lot of companies that weren't normally eligible for a small business administration loan now are. They've expanded to a certain extent the criteria and what constitutes a small business. And they're no longer looking at a specific gross revenue metric or anything like that. It's really the size of the employees of the employee database of what they're looking at as to whether you qualify. The second prong of that, though, is it could arguably be expanded to be more than 500 employees if an NAICS code applies. So again, it depends on your industry, okay, and your business. But here's an example. There are certain automotive manufacturers, okay, suppliers who are still considered small if they're 1,000 or even just under 1,500 employees. For that specific industry with that specific code, while you might not meet the first prong, which is the 500 employees, you might actually get some wiggle room to increase that depending on the industry that you're in. It's a little nuanced, it's a little complicated. offline here after the webinar. You can reach out to us and we can help you navigate those waters. But I'm going to give you a big warning here, okay? This is where everybody's hearing 500 employees or even this code that takes it up to potentially 1,500 employees, and everybody's asking the question or thinking that they're automatically going to be eligible. And you have to be aware of the affiliation rule, okay? So in the previous version of the SBA code and everything that was applicable to that, and even with the modified version, you don't get, or you're not eligible for this when you include the employees of domestic and foreign affiliates. So here's a quick example. If you're a small automotive supplier with 92 employees, you might think right off the bat that you're eligible. But if you are owned, okay, by maybe a German parent or a Japanese or even a Chinese parent, and with their location in Germany, they've got 2,000 employees, that number is attributed to you under the affiliation rules. So instead of being 92 and they got 2,500, you're 2,592, and that would take you out of eligibility status. So this is something that we offline, whether you're a client or you want to be a client, we can work through you on to help get you through this and calculate this, but it's not as crystal clear as most folks are thinking or as the news stations are portraying, okay? They did waive some of these affiliation rules, okay? If you've got a code with 72, hotels, inns, food services, restaurants, caterers, the like, that requirement is waived. You can actually have 500 or under per location. Same thing with franchise businesses. There's a lot of franchises out there who've got multiple locations and multiple employees across the country. There's a waiver for them, and then some other ones. But generally speaking, if you're not excluded, these affiliation rules apply, and it's something, it's case by case, client by client, industry by industry, you have to look at, okay? This also applies eligibility for sole proprietors and independent contractors. They could get some of that money. And then a big thing here, I've gotten this from a number of clients. Hey, if I start up a new business right now, can I just apply for the loan and use it to pay some new employees? And the answer to that is no. You must have been in operation on February 15th, 2020. So let's say you're eligible, okay? How big of a loan can you get? So the maximum loan you can get under this program is $10 million. I'll walk through the other calculation. If you go through this calculation I'm about to explain to you, and it came out to 12 million, you're capped out at 10 no matter what, okay? Now, you might, and most people will probably get less than 10 million, okay? You gotta have a pretty sizable payroll in order to get to that 10 million mark. But what you do is you take the average total monthly payroll costs over the last year, so 12 months from the date that you're applying for the loan, and you multiply that by 2.5 or 250%. In the first iteration of the legislation, it was 4. I don't know why they took that down. I think I know why, but there's no point in speculating at this point. The number is the number. So it's payroll costs over the last 12 months, the average of those total monthly payroll costs times 2.5, and that would be the amount of the loan you would be eligible for. Now, how do you calculate those payroll costs? It does include the compensation, so salary, wages, commissions, cash tips that people receive. It does include the payment for vacation, parental, medical, or sick leave. It does include severance. It does include healthcare benefits, including the insurance premiums. And it does include state and local taxes. What's not included is employee and compensation over the $100,000 mark, okay? So if you've got someone who's making 150 or 200,000, you can use them for calculation purposes, but you're capped out at the $100,000 mark. Certain taxes are not going to be eligible, of course. You cannot use the comp of employees whose principal place of residence is outside of the U.S. And there's a credit that you can't double dip, qualified sick leave and family leave. That if you got a credit through the Families First Coronavirus Response Act, you can't use that to calculate these payroll costs. So there is a little bit of debate. If you've got an employee who makes $85,000 a year and their benefits are $30,000, okay, you probably can use the 15 to take you to the 100 grand cap. Can you use that remaining 15K? The language of the act makes that a little ambiguous. So I would probably be calculating both just to be safe. And then as we get more clarity, hopefully in short order, and as you work with your banks, you might get more clarity through that. We just don't have a definitive answer on that 100 grand cap as it relates to benefits if it exceeds 100 grand right now. Let's say you get the loan. Let's say it's 2 million, 5 million. Let's say you get the full shebang. It's $10 million. What can you use the loan for? Well, you can use it for the payroll costs to keep those people employed. You can actually use it to pay off interest on mortgage obligations. So if you own a building and you're paying a mortgage on it, you can use it to pay pre-existing interest. You can use it for rent. If you are a professional services firm or an auto supplier or a mom and pop who have rent obligations to your landlord, you can actually include that. Use those proceeds to pay off those expenses. Utilities, and then interest on any other debt obligations that were incurred before the covered period. Now look, in reality, I don't know how much of the rent and the utilities and the interest is it going to be available, because the whole condition and the whole purpose of this program is that you're going to use the loan to keep people on the payroll. But we can kind of get into that later. Is the loan forgivable? This is where the whole phrase free money comes in. And as the secretary, the Treasury Secretary said, yes, if you use it to maintain the payroll, keep people employed during the covered period, this would be forgiven. Now look, that's the intent, that's the messaging. Within the act itself, there's a little bit of ambiguity on how you calculate that forgiveness. Brett and I can talk about that a little bit more. It may leave some room for some gamesmanship, but at the end of the day, if you take this loan, if you're eligible for it, and you keep your people employed, you should be in good shape to have the entire amount forgiven. Now, there is a scale and there is a calculation. That forgiveness will be reduced if you take the loan and you end up laying people off during the 8-week period. Okay, so if I've got 100 employees and I maintain the 100 through the period, you should be good to go. But if you let go or RIF or furlough 25 of them or 50 of them, there'll be an accompanying reduction in your forgiveness eligibility. You also have subtractions if you reduce the salary or wages paid to an employee by more than 25% during that period. So that by itself says you might be able to reduce compensation to a certain extent, but if you're going beyond the 25%, you'll run into some issues in terms of the amount that's forgivable. There's some of you out there who have already laid people off, or you might not be in a position for whatever reason. And there's a debate right now going on as to whether if you waited until June 20th or June 30th to hire them back, if you could still get the entire amount forgiven. We're still waiting on some regulations and some guidance. People who read it that way, and they may be right now in reading that way, if that were to be true, that would really undermine the purpose to a certain extent of the act. You can play a game of chicken. Maybe I'm taking Brett Miller's phrase, but it's a kind of a game of chicken with the government if you wanted to play those games. But I think the best guidance and clarity we can get you right now is if you're taking the loan, and you rehire those folks or you keep them on the payroll for the period of time, you're going to be in the best position possible to get the entire thing forgiven. If you play games, you're exposing yourself. And we'll come back to that in a second. What about What if the loan's not forgiven, or at least a part of it's not forgiven? What happens to the rest of it? The portion that's not forgiven is carried forward as an ongoing loan. So you'd have a max term of 10 years and a max interest rate of 4%. So all things considered and compared to other SBA loans and availability programs, those are pretty good deals. So if you're trying to keep the company afloat or trying to survive or trying to take care of your people, this is a pretty darn good access to a program. Even if it's not forgiven or part of it's not forgiven, these terms are pretty generous, all things considered. In terms of the payment schedule, the principal and the interest would continue to be deferred for a total of 6 months to a year after the disbursement of the loan. There's no restarts on that, but you also got some built-in flexibility on when you got to start paying that back. Let's talk about the process. Let's say you're eligible, or you think you're eligible, and you want to get this loan and you want to get in line as quickly as possible. And people are saying, Bernie, Brett, Jonathan, Steve, what the heck do I do? What's the process? And I'll give you 3 pillars right now. Number 1, contact your lawyers. Okay. Those of you who are clients of the firm, certainly, keep us in the loop. We can help guide you as this process goes forward. If you've got other attorneys or someone out there, or you want to call us, certainly reach out to us. We are here, ready, willing, and able to help kind of guide you one-on-one through the process and navigating eligibility and all those kind of things. So hopefully you can get that process started talking to your lawyers. Number 2, contact your CPAs and your bookkeepers ASAP. There are some things that you're going to want to get going right now, so when things go live, you're ready to go. And then 3, contact your bank immediately. Okay, if you don't have the bank, call a bank. This program is supposed to be available and rolled out through most banks and financial institutions. I would recommend banks or institutions that are already SBA 7A certified. They've got the better infrastructure, most likely, to kind of administer these loans and these programs and to work with you. The banks are, I don't want to say they're behind right now, but again, remember, the legislation wasn't passed until this past Friday. Okay, so it wasn't signed into law until about a few days ago. The banks are working overtime right now to get a process up and running. Secretary Mnuchin yesterday, or was it 2 days ago, said that he expects the program to go live this Friday, April 3rd. Maybe a little sooner, maybe a little after, but they're trying to ramp this up as quickly as possible. And actually today, I've been talking with a number of banks. A few of them have actually gone live with advertising the program. The applications aren't ready for submission or distribution just yet, but they're already advertising on the bank websites the program, including this program that's available and what you would need to have ready when they're ready to go forward with the process. Let's assume an application is made available on Friday, and let's assume it's online, and let's assume you're kind of ready to go. Everything should be done online, especially with these quarantine requirements and everything else. You should be able to submit everything through your bank online, whatever bank you decide to go to. The purpose of the Act 2 has been to really remove a lot of red tape as well. So the federal government's 100% guaranteeing the loan. They are only requiring that you, as a company, self-certify that you're eligible. There's already a presumption that you're affected by this crisis. There's no requirement for personal guarantees or collateral. They're trying to expedite this and make this go as quickly as possible. And even once you hit that submit button, the bank has 15 days and only 15 days to approve it. So for the most part, most should be approved. And hopefully it's days and not 15 days, but we'll see. When you apply for forgiveness, that's going to be done through your lender as well. And you're going to need to verify the number of employees, the rent, and you're going to have a certification. And that'll be done through your bank. So let's get into some questions that we're kind of, the Act's great, maybe you're eligible, but this is where the business world meets the legal world and all these employment issues come up. So I'm going to These are the 4 hottest questions we're getting, and certainly we'll take questions at the end. But let's talk about, Brett, I'll rope you in here, a resident labor and employment expert. Those companies that have laid people off or have furloughed folks or are really considering doing that. How do you reconcile those decisions or potential decisions with this PPP loan itself? How are you dealing and advising clients on that?
Yeah, Bernie, that's a great question. I mean, the new PPP program really changes the landscape for decisions about layoffs or furloughs. As an employment attorney looking at this on a workforce management level, it's a game changer. So it applies if you've already laid people off and you're going to bringing people back, or if you're considering layoffs, furloughs in the future. And it's a kind of common misconception is that people think if I've already had to lay people off due to Governor Whitner's executive order, due to restaurant closures, just anything related to this crisis, you're not precluded from utilizing this law. As you mentioned earlier, the loan looks at an 8-week period that begins upon the origination date of your loan, and then that's going to be your one of your measuring periods to look at for loan forgiveness. So really, if you've already laid people off, the law wants you to bring them back, get the money to keep them on payroll during this period, and then calculate your forgiveness later. Same thing if you're looking at a prospective layoff. The law is really changing the perspective there to prevent layoffs, keep people on payroll, and make sure that you can then take advantage of the loan and the loan forgiveness, even if there's not quite the work that you need for these individuals. You keep them on payroll, and as you said, at that point, on paper, looks like it could be free money if you get all the forgiveness.
Thanks, Brett. I need to go backwards here. My apologies. I'm messing up these slides. My fault. Let's go to question 2, Brett. And this is phase 3, and they're already talking about phase 4 and phase 5. But even back with phase 2, there's a lot of employers who have been navigating. And you did a webinar just last week, if I recall correctly, on the whole Families First Coronavirus Resources Act and these new paid leave laws. And now with this CARES Act, there's a lot of questions about how you reconcile this, because it does touch on both. And have they kind of penalized themselves by taking advantage of the former? Is that some kind of prohibition on them applying for the CARES Act? Can you talk about that reconciliation issue that a lot of employers are struggling with right now, and how they can kind of navigate those waters?
Sure. So just kind of high level to that point, Bernie. I mean, the FFCRA is a law that is going into effect tomorrow, April 1st, that puts into place 2 new paid leave laws for employees affected by COVID-19 for various reasons. If you're under 500 employees, it could affect your business and require paid leave for workers in certain scenarios, but it's reimbursable through the government through withholding of payroll taxes or a tax credit. So where that law intersects with the CARES Act is there's nothing to prohibit you from using the FFCRA. There's nothing that precludes you from applying for a loan under the CARES Act if you're utilizing paid leave under the FFCRA. The intersection really is that the government doesn't want you double dipping on the reimbursements. So the CARES Act specifically says, look, if you have people going off on paid leave under this new FFCRA law, you got to utilize that program. You've got to utilize those payroll withholdings and tax credits to pay those employees. You can't utilize those tax credits and then use the loan forgiveness under the CARES Act to pay for payroll. That's double dipping. You can't do it. You got to go through the route of the FFCRA. So they've provided some clarity on that point, which I know was kind of a question for a lot of employers.
All right. How about these? I don't know how much of a legal question this is, and this was a hotly debated component of this act, but these enhanced unemployment benefits, okay? Can you talk to those enhanced unemployment benefits and maybe some predicaments that employers and businesses are going to deal with?
Yeah, absolutely. I think we've all read the news about the number of unemployment claims across the country and here in Michigan. And what the new CARES Act does is provide enhanced unemployment benefits of $600 per week in addition to whatever benefit the employee is entitled to under state law. So in Michigan, that could be up to $362 per week for unemployment. On top of that, the federal government is kicking in an extra $600 per week for that employee. So we're talking about, over $900 a week to be on unemployment. Which a 40-hour work week, that comes out to like 24 bucks an hour. It's a pretty good, benefit for unemployment. It's such a rich benefit in some cases that Congress was concerned that there's going to be, it's incentivizing people to stay home and not work. And, again, if you're looking at a lower wage earner, $2,400 or $24 an hour to not work is probably pretty good money. So there's a real concern, in some circles about wanting to bring people back from layoff or furlough, or people who have been unemployed for some period of time due to the COVID-19 crisis, so that they can maintain their numbers, get the loan to make payroll, and then have that loan forgiven. But if you have people who don't want to come back to work, that can certainly be a problem and affect some of your employment decisions moving forward in terms of how you think you're going to have these loans forgiven, what kind of percentage of your workforce you're going to be able to get back. And again, really for those lower wage earners, that could be a concern for some businesses, because the enhanced unemployment benefit, really provides a benefit that we've never really had to deal with in an employment law before.
Yeah, and it really is crazy. I mean, like you said, the example that Tim Scott and Lindsey Graham were given was, hey, you can make $24.07. What's the incentive? So, you might want to pay everybody, but they might not want to come back. And those are just issues you're going to have to navigate. How about here in Michigan, Brett? I mean, you touched on this briefly when we were talking about number one, I think, but hey, I want to take the loan, but I've effectively been shut down. I'm not an essential service. We can't really work from home. My business has effectively been closed because of the governor's order. Can I still take advantage of this loan? And if so, how?
Yeah, that's been a common question too, Bernie. And the law, again, is designed to get people back to work. So it doesn't require you to actually have work to give people. It is designed to keep people on payroll, maintain payroll costs, have people maintain their health benefits, have people maintain their pay so that they can pay their bills during this time. So there's nothing, if you're a restaurant or if you're in a business in Michigan that's closed, non-critical infrastructure under the executive order, you may not have work for people to come back to, but that does not preclude you from applying for the CARES Act, trying to get this loan and the forgiveness. And in fact, for a lot of businesses, that's certainly, there's really no downside to rushing to try to get that money.
Sounds good. All right, folks, let's kind of move on. I'm going to pass the baton to Steve Etherly. Let's say you're just, for whatever reason, you get caught in the game where you're just not eligible as a business for the PP loan. Are there other options out there for you? And for some of you who might be a little bit, you're too big for the eligibility. Let's say you're 600 or maybe 1,700 employees or more. Is there anything or any other opportunities out there for you? I can tell you there's no deal as good as the loan that turns into effectively a grant that's not taxable. Okay, this PPP loan everybody wants to get their hands on, but there are other resources out there for you if you're kind of on the bigger end of things. And my colleague Steve Etherly kind of walk through what's available and the strings attached, so to speak. So go ahead, Steve.
Yes, thanks, Bernie, and good afternoon. So Title IV of the CARES Act provides $500 billion in emergency relief funds. If you've been following this legislation on the news, you may have heard this referred to as the slush fund. So what's in the fund? So there's $29 billion for airlines, and then there's $17 billion for businesses important to maintaining national security. Now, this language is not defined in the Act, but from following this legislation, most likely it's referring to Boeing and General Electric. So the remaining 454 billion is to support lending to eligible businesses, states, and municipalities. So these are lending programs administered with the Federal Reserve. So this fund will be overseen by the Coronavirus Inspector General and the Congressional Oversight Commission, which was a 5-person panel appointed by Congress. And the Treasury will publish procedures for application for this money and the minimum requirements on April 6 or 10 days after enactment. And so as Bernie mentioned, this is assistance for mid-sized businesses. So we're talking between 500 and 10,000 employees. And these will be direct loans with interest rate not higher than 2% and no principal or interest due for 6 months or longer. So this looks like a great deal, but there's always a catch. And the strings that are attached, you must certify in good faith. And now come the strings. You must have uncertainty of economic conditions, which is given a low bar, given the circumstances we're in. And funds will be used to retain at least 90% of workforce at full compensation and benefits until September 30th, 2020. Also, the company will restore not less than 90% of workforce that existed as of February 1st. The company must also be domiciled in the United States with significant operations and majority of employees in the United States. And no debtor, and the company cannot be a debtor in a bankruptcy proceeding. Companies also may not pay dividends or other capital distribution or repurchase of stock or buybacks for the term of the loan plus 1 year. Further, companies are not allowed to outsource or offshore jobs for the term of the loan plus 2 years. And now finally, there are two conditions involving labor. The first being the company is not allowed to abrogate collective bargaining agreements for the term of the loan plus 2 years. And also the company must remain neutral in any union organizing efforts for the term of the loan.
Steve, from a labor standpoint, I can tell you a lot of my clients would consider these last 3 subpoints to be deal breakers. The law is very vague on what outsourcing or offshoring of jobs means. It's unclear if a company's ready to, open a plant in Canada or Mexico, if they're suddenly precluded from doing so if they take advantage of this loan. The labor provisions are considered extremely anti-employer. Neutrality in a union organizing effort is essentially, giving up the right to tell a company's side of the story during an organizing effort or election campaign, and it really almost kind of can guarantee that union organizing effort would be successful. So really kind of big red flags. You mentioned strings attached. I mean, those are some serious considerations for employers who would be looking at this potential assistance.
More strings. So the act also limits on employee and executive compensation to 425,000 cap for officers and employees while the loan is in effect plus 1 year, and also places a $3 million cap for officers and employees plus 50% of whatever he or she received over that in 2019. And although not listed, there is a conflict of interest provision that prohibits participation of entities which elected federal officials, heads of executive branch departments, or their family members with controlling influence. So they're not allowed to take any money under the fund. Now, these limitations can be waived, but the Treasury Secretary must testify in Congress about the specific reasons and why, in the circumstance, a provision must be waived. The Act also references the Main Street Business Lending Program without any details, but this program is supposed to be it's supposed to support lending to small and mid-sized businesses on terms and conditions that are consistent with the Federal Reserve Act. And also that mid-size or any employers may possibly take advantage of. There's also an employee retention credit for closures caused by coronavirus. Again, this is for any eligible employer. So this is both small and big businesses. And the credit is 50% of wages for each employee. But there is a restriction, as companies are not allowed to apply for this credit if you're also taking advantage of the Paycheck Protection Program, as talked about earlier. So there's no double dipping for small businesses on this credit.
All right, Steve, thanks so much. We're already getting a whole bunch of questions. If you got a question, you can submit that through the chat. We're going to try to leave enough time to get through as many as we can before the end. But I want to turn it over real quick to Jonathan Kirkland. We're talking about the CARES Act. We're talking about the Paycheck Protection Program. We've talked about some larger businesses and availability there, but there are some other programs that you might be eligible for. And Jonathan can kind of walk through those quickly and shed some quick light on those. So Jonathan, go ahead.
Yes, good afternoon, everyone. I'll briefly touch on some of the additional financial relief and programs for small and mid-sized businesses. So these programs were already in existence prior to the COVID-19 pandemic. However, the CARES Act expands those programs through additional funding. So we will speak in detail on the Small Business Administration Emergency Injury Disaster Loans, commonly referred to as the EIDL. And then quickly, I will discuss the Women's Business Center Program, the Minority Business Development Agency, and the Entrepreneurial Development Program. So in regards to those last three programs that I mentioned, the CARES Act will authorize grant funding for the Women's Business Center Program, the Minority Business Development Agency, and the entrepreneurship programs to provide education and training to women's business enterprises and minority business enterprises in the areas of securing federal funding and managing a business amid the COVID-19 pandemic. So I know there's a lot of women's business enterprises and minority business enterprises that we advise. You guys are a part of those programs. You are able to receive free training and education as to what's available for you. Additionally, the CARES Act also waives the matching funds from non-federal sources requirement for entities receiving assistance under the Women's Business Center program. So typically you have to match dollars from non-federal sources, and now they're going to waive that requirement for a couple months. Now, moving to the SBA EIDLs. The EIDL program is expanded for a covered period, which is between January 31st, 2020 to December 31st, 2020, and authorizes an additional $10 billion to help small businesses impacted by COVID-19. The U.S. Small Business Administration has designated COVID-19 as a qualifying event for the distribution of the EIDLs. The EIDL is a low interest, fixed rate loan that can provide up to $2 million in assistance per loan. And actual loans are based on the amount of economic injury, but they do not replace lost sales or revenue. So the big question here, and you will hear some common themes, who is eligible for these loans? So eligible businesses are businesses generally with less than 500 employees. The one exception is if the SBA table of size standards defines the small business in a specific industry as greater than 500 employees. So Bernie talked about this in great detail under the PPP. The same thing will go for it here. So if you're in an industry that says a small business is 1,000, 1,500 employees or greater, you still may be eligible. So definitely look into it. What can the funds be used for? The EIDL funds can be used for payroll, accounts payable, employee sick leave, and other bills that cannot be paid due to the pandemic's impact. What can the funds not be used for? EIDL funds cannot be used to refinance debts incurred before COVID-19, make payments on other loans owned by a federal agency. This includes prior SBA loans that you may have. It cannot be used to pay tax penalties or non-tax criminal civil fines. It cannot be used to repair physical damage, most likely to real property. And it cannot be used to pay dividends or disbursements to owners or partners, except as related to their services for the business. Lastly, the CARES Act waives requirements under traditional EIDLs, including 1, the requirement for a personal guarantee on advances and loans less than $200,000. 2, the requirement that an entity has been in business at least 1 year, although the entity must have been in operation as of January 31st, 2020. And 3, the requirement that an applicant is unable to find credit elsewhere. Now I would like to turn it back to Bernie.
Thanks, Jonathan. And look, folks, this is a lot to digest. This is happening quick. I mean, again, it's the largest rescue package in American history, and it's certainly the fastest. And all the intentions sound great, but there's a lot of minutia that's out there that you got to navigate through. And we're here to help in that regard. So we've put together a CARES Act assistance team. Certainly the 4 of us have been involved and can speak to different specific areas. We've also got other team members, including Suzanne Miller for tax, Tom Cable on the SBA and the landlord side, Mark Lozat, as this applies to nonprofits. I know there's a lot of questions about nonprofits and the applicability and what they can do. Deb Giroux from a healthcare perspective. We got our retirement duo and Nancy Kippelman and Bob Stevenson. And even from a bankruptcy standpoint, those looking to restructure and who have concerns about taking this loan and how that might affect that. We've got Tom Radom and Max Newman. So a lot of this goes together. One issue is just not exclusive. It usually overlaps with another. So again, we've put together this team to kind of help you guys navigate those waters. So after the webinar, you can certainly reach out to anybody on this webinar, and certainly anybody listed here or any other Butzel attorney to kind of help shepherd you through that process. Now I just want to get into questions. We've got some time available here. I'll start off with a few here, and then we'll just kind of get through as many as we can before 4. And if there's more questions, you can hit us up offline. Okay. So the first one that I've got is, Bernie, what the heck do I need to bring to the bank? Okay. Well, we finally have gotten some clarity from at least some banks. They are actually letting you know that, again, with your own CPAs and bookkeepers, start getting those formulas ready to go. But they're asking for the 2019 and 2020 year-to-date monthly profit and loss statements, so your P&Ls, 2019 and 2020 year-to-date payroll reports, your state income, payroll, and unemployment insurance filings, have that ready to go. And certainly, obviously, your tax ID and your EIN and all the complete ownership information. So kind of have that ready to go. And again, I can't hammer this home enough. Start talking to your bank now. It might go live Friday, but you want to get as much done as you can now. So it's a simple click of the button as soon as possible. Another question we got is, will small U.S. companies owned by a foreign entity be eligible for the personal protection program, or excuse me, the Paycheck Protection Program? And the answer to that is maybe. okay? I gave an example earlier. You might be a small supplier in the grand scheme of things, 92 people or 150 people here in the US, and that might be okay at first glance, but if you are owned by a foreign entity, those numbers will be attributed to you from an employee standpoint. So if you are owned by a company overseas and they've got 2,500 employees, you got to add that number to the 92, okay? And that would take you out of eligibility, at least for this portion of the act, okay? So again, you've really got to find out what industry you're in, the code, and your availability, and start adding those total employees, both through parents and other affiliates. So that's a question. Here's a question here, Brett, I might kick this to you. Do you have to bring the same employees back that you laid off, or can you hire new workers to meet that monetary or that number threshold? What do you think, Brett?
It's a great question. The statute only speaks to the number. It refers several times in there to bringing back the number of employees, which to me implies it's not the exact same human beings that worked for you in the first place. It's the same number of people. And this formulas talk about calculating your average FTEs during certain time periods. So again, it's not requiring you to have the same FTE who worked for you at some time, simply making sure that you have those same numbers. And as a practical matter, I'm not sure how the government would even track that. I mean, going through your payroll records to see if, Joe Smith was replaced with Susan, I mean, it seems like it would be a nightmare to enforce if they took that position. So right now we're kind of under the assumption that as long as you have the same numbers, they don't have to be the same people.
Another question we have is, why would a bank not approve this loan? That's a good question. Requires a bit of speculation, of course, but look, the whole purpose of this is to make it as easy as possible, right? So the Federal Reserve is guaranteeing the loans 100%, not 75% or a lesser amount. They're guaranteeing the loans completely. They're paying the bank's processing fees, and assuming you're self-certifying, and there's no personal guarantees. So really the banks are the middlemen or the middlewomen, and it would take a lot in my mind for them not to approve it. It's really teed up with all the red tape removed and all the confirmations removed for them to be approved. Now, I think that does set itself up for a lot of folks who could be gaming the system, fraudulently getting loans. Who knows? I think that's a genuine concern, because there's only so much checking they could do. So, but for there being some very suspicious or blatant things that the banks can catch, I think they'd be hard pressed not to approve folks if they truly are eligible. That does factor into was this company in business February 15th, 2020, before this all happened? That might be one thing that they can use. But to answer your question, I don't know what's going through the bank's mind and their processes and procedures, but I think they'd be hard pressed not to approve folks who are doing it the right way and self-certifying with the documentation. Brett, I'll kick this one back to you. What about independent contractors? Let's say, you got employees that you W-2, but let's say you got people that you employ 1099. Are they covered? Can they be factored into the calculation?
Yeah, that's a good question. And typically right now it's looking like, while there's some ambiguity on sort of catch-all, in terms of what other purposes you can use this money for, it's really designed for employees. The statute talks about FTEs, employees, those are going to be W-2 and on your payroll. And independent contractors are typically not on your payroll. They're on, your accounts receivable. So it's a different question if you are an independent contractor, it's, self-employed, an Uber driver, and you're trying to, or, take advantage of some of these provisions. But from an employer standpoint who has employees who are W-2, you also have some workers who you are independent contractors that get 1099s. At this point, we do not believe you can count the 1099 contractors under the same formula. And frankly, as a labor and employment attorney, I would be really hesitant to even try that, because we try so hard to tell everyone that independent contractors are not employees. I wouldn't want to be putting something down on paper somewhere trying to lump them in with your employees.
Right, that's a good point. And again, I think a lot of this stuff, folks, it's all happening fast, but I think there's going to be a lot of after the fact litigation and issues that arise out of this whole process. How about this question? Maybe you and I can tackle this one, Brett. Do you include owners for the up to 100K calculations? So maybe those owners who pay themselves a salary and are also employees and running the business as well. Can they be factored into the calculation? I think they can, much like if you've got employees who are and owners of the business, multiple owners who make well over $100,000, you certainly can't include the amount over that, but I think you could use the threshold up to 100K to use for them. Would you agree, Brett?
Yeah, I agree. You'd want to really double check the the comp for that owner and how all that works, and looking at that cap. But I mean, this is a law that talks about self-employed and kind of giving some more discretion to include an owner that we don't usually see. So that's definitely a possibility.
Okay. What about this on the maybe Brett and Jonathan? We've been debating this, and this question's coming. The 8 weeks and the forgiveness aspect, the covered period. Can you provide some clarity on that as to how that works?
Well, this is Brett. I'll take the first crack at that. I mean, so there's you saw some slides with the throwing around some language about an 8-week period and the covered period, and what that does is, on my end, focusing on the loan forgiveness aspect, you're supposed to be kind of creating a formula for the CPA and CFO types out there, where essentially that 8-week period is the number of FTEs you have in the 8 weeks after the loan originates. Okay, that's going to be your numerator on any formula for calculating the loan forgiveness. FTEs over that 8-week period. The denominator is then what we know now, and it's a little bit vague, but under the statute, the denominator of that formula would be the average FTEs from, it would be either the average FTEs from February 15th, 2019 through June 30th of 2019, or the average FTEs from January 1st, 2020 through February 29th, 2020. And there's some, you get a little granular. There's a lot of stuff going on there, but when we start talking about that 8-week period, when we start talking about how to calculate the actual sliding scale of loan forgiveness based on how many employees you've brought back to work or maintained, we get into some of the complicated areas of this law that we're still waiting for regulations. But from a high-level standpoint, employers should be aware that once they originate that loan, they're kicking off sort of this 8-week period where the government wants them to have people working. So, recalling the workers to be available during that time period, or maintaining that workforce. And so it's kind of, when employers are going to make the application for these loans, they really want to figure out what they need to do with this workforce before they're kind of making that determination.
All right. Okay, so we are up against the clock here. I really want to thank everybody for attending the webinar. If you've got questions, if you need help, look, this is complicated stuff, folks, and I understand if your heads are spinning right now. I get it. I've been there. If you got questions, you can reach out to any of the four of us. We'd be happy to set up a time to talk with you and really delve into it further one-on-one. And certainly you can reach out to any other Butzel Long attorney and we can put you in the right direction. Okay. But any of those questions, reach out to us. Thank you so much for your time. a lot of moving parts. We're going to continue to follow this, track this, and update it as it goes along. So again, thank you for your time. We really appreciate it, and good luck, folks.
Thank you, Bernie, and thank you the rest of the presenters. And thank you everyone for joining us this afternoon for this webinar. A copy of this webinar, the slides, as well as a recording, will be made available later on today on Butzel.com and in our Coronavirus Resource Center. So please feel free to download and follow up with any of the presenters if you have additional questions. Thank you, everyone, and have a great afternoon.